Hello and welcome to Courts This Week on LiveLaw. I am Taniya Pandey and I hope you've all had a wonderful Diwali. On Courts This Week, we cover the most recent judgments from courts across India. Let's begin the episode with judgments from the Supreme Court, followed by High Courts and other courts. The Supreme Court has held that prior sanction of the magistrate is not mandatory for investigating a non-cognizable offence along with a cognizable offence. A bench of Justices M.R. Shah and A.S. Bopanna was dealing with an appeal against a judgment of the Jammu and Kashmir High Court, which quashed an FIR for offences under the J&K Prevention of Corruption Act and criminal conspiracy under Section 120B of the Ranbir Penal Code. The Supreme Court held that the High Court erred in holding that sanction of magistrate was required to investigate the non-cognizable offence as the offences under the Prevention of Corruption Act were cognizable. The top court also noted that the offence under the Prevention of Corruption Act is a substantive offence, and when it is coupled with the offence of conspiracy, there is no requirement of prior sanction of the magistrate. The Supreme Court has held that the requirements specified under Section 25F of the Industrial Disputes Act 1947 for the retrenchment of an employee will apply even if the appointment was irregular. A bench of Justices Ajay Rastogi and Abhay Oka disagreed with the view expressed by the Kerala High Court that Section 25F of the Act will not apply if the appointment was irregular and reversed the High Court's judgment. The Apex Court observed that nature of employment and the manner in which the workman has been employed is not significant for consideration while invoking the mandatory compliance of Section 25F of the Act of 1947. The Supreme Court laid special emphasis on the fact that Section 25F uses the words "for any reason whatsoever" with respect to its application to retrenchment. The Supreme Court has held that a will cannot be revoked by an agreement and can be revoked only as per the modes specified under Section 70 of the Indian Succession Act. A bench of Justices Ajay Rastogi and Abhay Oka clarified the essential ingredients of Section 70 of the Indian Succession Act required to be fulfilled in a case involving a question of revocation of will by a subsequent agreement. The court noted that as per Section 70, revocation can be made by one of these methods, which is by execution of another will or codicil, or a writing executed by the testator declaring an intention to revoke the will and executed in the manner in which an unprivileged will is required to be executed, or by burning, tearing, or otherwise destroying the same by the testator or by some person in his presence and by his direction with the intention of revoking the same. The Supreme Court has granted leave in a special leave petition which raises the issue whether education is a service within the Consumer Protection Act 2019. The bench of Justices D.Y. Chandrachud and B.V. Nagaratna noted that this issue is pending consideration in another case titled Manu Solanki vs. Vinayak Mission University. In this case, a boy participated in summer camp organized by his school. He drowned in the swimming pool of the school and later died. His father filed a consumer complaint in the State Consumer Dispute Redressal Commission, alleging negligence and deficiency in service on part of the school. The State Commission dismissed the complaint as not maintainable. In appeal, the National Consumer Disputes Redressal Commission, NCDRC, took note of its larger bench in Manu Solanki and Supreme Court judgments and held that educational institutions do not fall within the ambit of the Consumer Protection Act 1986, and education, which includes co-curricular activities such as swimming, is not a service within the meaning of the Consumer Protection Act 1986. Therefore, it dismissed the appeal. Admitting the SLP filed against this judgment, a 3-judge bench of the Supreme Court had noted that there are divergent views in this regard. The Supreme Court has observed that mere apprehension of threat to life is not a sufficient ground to transfer a case without lodging a complaint or substantiating the said ground. In this case, the petition sought transfer of complaint filed under Sections 420 and 506 of the Indian Penal Code, pending in the Court of Chief Judicial Magistrate Jammu to the 30 Hazari Courts, Delhi. One of the grounds raised in the petition was that there is an apprehension of threat to life. The petitioner had also relied on the decision in Puneet Dalmia to seek exemption from personal appearance. the Supreme Court held that the order passed in Puneet Dalmia's case did not apply in the instant transfer petition merely on the basis of apprehension and dismissed the transfer petition. The Supreme Court has reiterated that intervention under Article 136 of the Constitution is not called for merely because a different view about the High Court's judgment is possible. A bench of Justices Indira Banerjee and S. Ravindra Bhatt made this observation while dismissing an appeal challenging a judgment of the Kerala High Court in a case related to vesting of private forests. While declining interference with the factual findings entered by the High Court, the top court observed that there is some authority for the proposition that where two plausible views on the conclusions that can be drawn from the facts on the record exist, the Supreme Court, in exercise of its discretionary jurisdiction under Article 136 of the Constitution, would not interfere with the findings of the High Court. Let us now go over judgments from the High Courts and other courts. The Delhi High Court bench of Justices Siddharth Mridul and A.J. Bhambhani has issued directions for streamlining the process of inquiries related to juveniles in conflict with law and scrupulous compliance by all authorities. The court was dealing with a criminal reference wherein questions of law were placed by a principal magistrate of a juvenile justice board concerning the circumstances when a child in conflict with law also happens to be a child in need of care and protection. The court also granted 4 weeks' time to the Delhi government for furnishing information relating to inquiries for petty offences pending before all juvenile justice boards in Delhi between 6 months and 1 year, including the number of such cases, along with the date of institution of the inquiry and date of first production of the juvenile in conflict with law. A Kerala High Court bench of Justice K. Haripal issued notice in a plea challenging the constitutionality of Section 494 of the Indian Penal Code, which provides punishment for bigamy. The petitioner, who is facing a criminal prosecution in a case related to bigamy, stated that Section 494 essentially classifies people based on their personal law and selectively criminalizes the act of second marriage based on the applicable personal law. Such an approach in penal legislation is not only arbitrary but unreasonable and unconstitutional. Therefore, it was argued to be violative of Article 14 of the Constitution, since it militates against the basic tenets of the constitutional mandate of equality. Additionally, it was contended that the provision lacked the element of mens rea. The Allahabad High Court has recently directed two premier institutions of India, IIT Kanpur and IIT BHU, to test the samples and submit a report regarding the quality of water in rivers Ganga and Yamuna. Importantly, while taking into account the complaints regarding sewage water falling directly into the two rivers, the bench of Justices Manoj Kumar Gupta, Siddharth Verma and Ajit Kumar also constituted a committee to get samples drawn from different points of the rivers. Since the court was not satisfied with the report of the Uttar Pradesh Pollution Control Board regarding the collection of samples and a subsequent report regarding the quality of the water, the court constituted this committee. The Kerala High Court on 2nd November ruled that while gold smuggling could threaten the economic security of a country, the same is not covered by the provisions of the Unlawful Activities Prevention Act. A bench of Justices K. Vinod Chandran and C. Jayachandran made the observation while granting bail to prime accused Swapna Suresh and 7 others in the gold smuggling case that had shaken the state in 2020. The court held that smuggling of gold is covered by the provisions of the Customs Act and will not fall within the definition of a terrorist act as defined under Section 15 of the UAPA. The Allahabad High Court has directed the Uttar Pradesh government to instruct the district magistrates of all the districts to re-evaluate the cases for remission after 14 years of incarceration, even if appeals in such cases are pending in the High Court. The bench of Justices K.J. Thakur and Ajay Tyagi passed this order while hearing an appeal filed by a rape convict challenging his life imprisonment sentence awarded by the Additional Sessions Judge, Special Court, Daikaiti Affected Area, District Kanpur Dehat. The court allowed the appeal of the rape convict, who had been in jail since 2008, and reversed the judgment, and the accused was convicted for the period undergone. After a span of over 27 years, A Delhi court has convicted former Delhi High Court Bar Association President Rajiv Khosla for assaulting a woman lawyer in the year 1994. Chief Metropolitan Magistrate Gajendra Singh Nagar was of the opinion that the testimony of the woman, qua her allegation of being pulled by her hair and arm by Khosla, and the threat that she will not be allowed to practice from the Tisazari court, was absolutely truthful and creditworthy. The court will now hear arguments on sentencing on November 15th. A Delhi court on 2nd November framed charges of rioting and unlawful assembly against 4 men in a case concerning the Northeast Delhi riots. It also observed that the delay of 5 days in reporting the incident to the police is justified, as there was an atmosphere of terror and trauma after the riots erupted in the national capital. Additional Sessions Judge Virendra Bhatt framed charges under Sections 147, 148, 149, 392, 427, 436 and 454 IPC against Mohammad Shehnawaz, Mohammad Shoaib, Shahrukh and Rashid. That's all for today. If you liked the information in this video, don't forget to give us a thumbs up and do subscribe to LiveLaw to continue watching our series. I am Taniya Pandey and you're watching Courts This Week. I wish you a great week ahead.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.